Hello, this is Pastor Mike in Southern Oregon. I'm making another video under the heading of, it'll be under either one of the headings, Investment in Truth Review or Real Life-Changing Truth. Today is February 22nd, 2020. The code assigned to this will be 2020 V for Video 004. The title is Second Amendment Limitations. Now, let me begin by reading the new disclaimer. I said I'd write a new disclaimer and improve what it was, and I did. And we're going to use the new disclaimer on this video today. So we'll just jump right into that. The information provided herein is for educational, truth, and knowledge purposes only. No specific course of action is directed except the advancement of knowledge and truth. The following understanding, opinion, and analysis is based upon the legal and related issues in the United States of America. For those who live outside the USA, you should consult the laws in your own country or consult with legal counsel. For those within the USA, if you conclude that my understanding, opinions, and analysis of the legal and related issues to be unacceptable or incorrect, you should do your own research, read the cases yourself, come to your own understanding and conclusions, or consult with legal counsel of your choice. As always, I, Pastor Mike Benjamins Jr., hereinafter pastor, or hereinafter called Pastor Mike, or referred to as Pastor Mike, address various issues as a pastor of God in my ecclesiastical office and capacity, primarily but not exclusively, to keep believers in God as well as others aware of their various rights, freedom, and liberty under God or man, and relative to their relationship with the various laws of man. No specific course of action is directed or implied, and the believer or non-believer should rely upon their own understanding, judgment, and conclusions upon which to base any acts or omissions for which they are solely responsible and are undertaken at their own risk, peril, and liability. Pastor Mike disclaims all liability and responsibility for the implementation of the understanding, opinions, or analyses set forth herein. The Remnant Church in Southern Oregon, as well as Pastor Mike, in both his personal and ecclesiastical capacities, including his subordinates and personnel, individually and jointly, disclaim any and all liability and responsibility for any damages sustained or suffered by the readers, viewers, or other entities in the implementation of the teachings set forth in this video or treatise. I reiterate, the material is provided as a research study project for learning purposes only, and any implementations, applications are undertaken at the sole risk and peril of such readers, viewers, or entities. No statement is made or implied as to the ultimate outcome resulting from such implementations or applications. So I'm not making any guarantee that if you implement something that I said, that it will work or not work. I'm not saying that it will work or not work. Therefore, I hereby declare, claim, and assert on behalf of the Remnant Church, its pastors and personnel, individually and jointly, any and all legal and religious protections of whatsoever nature and kind, including protection from discrimination on the basis of religion, available under the inherent, inalienable, primary, and subordinate rights and laws. Okay, let me talk for a little bit about what's going on in when I say Second Amendment, I may shorten that. In fact, I'm not the only one who does that. Other people do it too. Instead of saying Second Amendment all the time, we might just say 2A. That means Second Amendment. It makes things go a little faster. Now, here's what's going on. There are organizations out there, I'm not going to name them specifically, but there are organizations out there set up to help you protect your Second Amendment rights, they would say. And in the past, I've talked about a little bit. What we need to understand about what's going on out there is that's why I titled this thing Second Amendment Limitations. There are limitations as to how far you can get pushing a purely Second Amendment strategy. And that's what we're going to talk about today. I've talked about it here and there in different videos and writings, and I'm going to try to consolidate some of it in kind of a synopsis of what the most effective way of protecting your right to keep and bear arms is going to be, which of course is directly tied to your right to life and your right to self-protection, which are inherent and inalienable rights. You see, we have a situation where if we call these rights Second Amendment rights, it gives the idea that the right flows from the Second Amendment, which it does not. It's an inherent and inalienable right. Some people have actually used those words. They said, this is an inherent right, this is an inalienable right, and they revert right back to acting as if it flows from the Second Amendment. That's a problem, and I'm going to explain why somewhat in this video. Now let me read from a paper that I wrote some while back. It's entitled The Inherent Inalienable Rights of the Individual and the Tyranny of the Majority. And here's what I wrote. I said, we have long pondered, asserted, demanded, struggled, fought and died for the absolute rights of man. That, of course, comes from Blackstone's commentaries, that phrase, the absolute rights of man, which include pre-existing, inherent, human, natural, pre-political, and God-given inalienable rights. But, my friends and brethren, if we neglect to understand and acknowledge access to such fundamental rights, freedoms, and liberty, invested in the sovereign individual as an inherent and inalienable right, invested at the individual level, of course, as a necessary part of life and existence in a state of freedom and liberty at the individual level, separate from the voice of the collective sovereign people, through some application of presumed justification for, or seizure of power of the will of the majority by a process of voting or otherwise, thus bringing into reality the specter of a system of the tyranny of the majority over the individual's inherent and inalienable rights, freedom, and liberty, then, my friends and brethren, we have knowingly or unknowingly nullified and defeated the very concept and reality of inherent and inalienable rights, freedom, and liberty, far from the very doctrine of the absolute rights of man upon earth and beyond. In doing so, we have, contrary to the doctrine that we are all created as human beings upon equal terms, joined the ranks of the tyrants of history, who have, by their own beliefs, wants, desires, ambitions, justifications, agendas, and acts and omissions, wrought in seizure of power and dominion over others, by whatever means at hand, without the actual consent and agreement of each individual, declared by operation and practice that the inherent and inalienable rights, freedom, and liberty do not, in fact, exist. Okay, what is all that about? I mean, it's a long sort of statement. You may not gather everything that's in it. What it means is that we were all born or created, depending on how you look at it. You know, even those that believe that we were created by the hand of God, of course we were born as well. But there's some people don't believe in God, and they say, well, we were born with these rights. These are natural rights. These are inherent rights we were born with. The truth of the matter is, you have inherent and inalienable rights just by the mere fact that you were either created or born or both. The idea that as a collective people is the only way that you can assert those rights is, of course, ridiculous. Yes, the rights can be asserted, collectively, but that does not imply that they can only be asserted collectively. If you don't get that clear in your mind, you start to get confused, especially when you start dealing with the realities of the democratic system that we've all become used to. Now, how about the idea of sovereignty? Do the people have sovereignty? And if they have sovereignty, do they only have it in the collective capacity, or do they also have it in the individual capacity? Because you should be able to access individually your inherent and inalienable rights based on some application of the doctrine of sovereignty. Well, the answer is, let's first go to the case of Chisholm versus Georgia, 1793, and look at what John Jay wrote. If you're wondering, are the people sovereign? Here's what John Jay, Chief Supreme Court Justice John Jay wrote back in 1793. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country. But they are sovereigns without subjects. The citizens of America are equal as fellow citizens and joint tenants in the sovereignty. Chisholm versus Georgia. Okay, that makes you think that the only way they can exercise individual sovereign access to inherent and inalienable rights is collectively, which of course is not true. You have to go back in a time machine when there weren't as many people to start with, and people were mostly brought into existence as individuals, and they weren't even acting as a group per se. They already had various rights right there as an individual. Now, you can have a bunch of individuals who decide to act collectively and do something, and that, of course, is possible. Can they assert a joint sovereignty? In other words, can I add my sovereignty to yours and yours and yours and yours, whoever decides to act collectively, and say we're going to apply our joint sovereignty to something? Sure, you can. Of course you can do that. Don't get the idea that that because you have become part of a group dynamic or part of a group concept, that now you lose your individual right to inherent and inalienable rights, for you surely do not. Unless by joining the group you agree and consent to a diminishing of those rights. If you don't agree and you don't consent to let the group do that, so in other words, if you say, okay, let's say there's a group of undetermined amount of people, and you say, well, I've joined the group and I'm going to voluntarily say that I will abide by the decision, the majority decision of the group. And in doing so, see, you have the power to do that. You have an individual right to contract and agree to something like that. So in other words, you can agree to diminish your own inherent and inalienable rights. You can agree to do that. You have that power. It's part of your fundamental powers that, again, you were born with. You can do that. You can enter into agreements and contracts of that nature. The problem happens when we forget that we ever had that capacity individually. And therefore, can we withdraw our consent or agreement and say, I don't want to be bound by the group's decision anymore. I'm going to default back to my individual rights. Can you do that? Well, the answer is yes, you can do that. You can withdraw your consent. If they've had your consent, or let's say presumed consent, or implied consent, or assumed consent, because you didn't object, you didn't say anything, and they had your consent theoretically before, so they continue to assume and presume that they have your consent, and you're not saying anything. Is that possible? Yes, that's possible. Then it's on you to clarify to the group that you're withdrawing your consent. They say, yes, at one time, before I understood the issues fully, because I didn't know all the ins and outs of all this, I did give consent. But since then, I have learned more, and now I know that I don't want to consent any longer to diminish or not have access to my inherent and inalienable rights. That's important. That's key. If you understand that, and we're going to go, like I said, we're going to go into this more. If you understand that, then that gives you some options. The other thing is, let's go back to the Second Amendment again, like some of these 2A groups are the way they're handling it. They're saying, okay, well, we're asserting our Second Amendment rights. Let me state again. Don't say that. You're not asserting your Second Amendment rights. You already had the right to life. You already had the right to self-protection, and you already had the right to keep and bear arms. It pre-exists the Second Amendment. It pre-exists the U.S. Constitution, and in fact, it pre-exists the states and their laws. You already had that right. The reason, the problem is that people, as time goes on, people begin to forget how this all works. And this becomes generational. So, one generation follows another generation follows that generation, and pretty soon people forget. And then they literally are born into a democratic mindset. They say, well, this is all decided by democratic means. Which means that if the group decides that they're going to take away some of my inherent and inalienable rights, why, that everything is the way it's supposed to be. That's how it works. And then you say, well, what if the group votes a ridiculous piece of legislation into law? What then? And in the arena of the right to keep and bear arms, that's in fact happening before our very eyes. At present, there are some things going on in the state of Virginia and in other states too. And a lot of people don't know exactly what they're going to do about it. Now, if the vote goes their way, and the vote says, okay, we're going to let you keep at least you're going to let you keep the bulk of your right to keep and bear arms. There will be some restrictions, but you get to keep them. Then people are probably not totally satisfied, but they're satisfied. They say, okay, well, they're letting us keep our guns and our right to keep and bear arms, so I'm not going to complain too much. But the vote could go the other way, you see. Let me address real quick from a treatise that I wrote. This is a treatise on the inherent right of self-protection and the right to keep and bear adequate arms. This was done, compiled May the 8th, 2018 at 12:14 p.m. It is coded under Code 2018A0099. This is the overview treatise. Let me read something from here. Now, some of this is a little bit of review, but I'm not going to go into it as deep as I did before when I specifically made the videos having to do with the analysis of the Second Amendment. The Supreme Court of the United States in United States versus Cruikshank in 1875, this is cited under 92 U.S. 542, stated, "The right to bear arms is not granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. The Second Amendment means no more than that it shall not be infringed by Congress, and has no other effect than to restrict the powers of the national government." That was, of course, at that time, in 1875, that's what they said. before that, like it says here, it was only applicable to the infringement by the Congress of the United States, so by the federal government, basically. But that all changed. If you want verification, let me add this in. If you want verification that the Bill of Rights only applied, and the Second Amendment only applied to the federal government, that would be in the case of Barron versus Baltimore in 1833, and this court stated that. Everything changed later on when in 1868 they brought in the 14th Amendment, which brought in the possibility of the federal government being able to incorporate parts or the whole of the amendments upon the states. And the truth of the matter is this. The Second Amendment did not even apply to the states until 2010, because it wasn't incorporated upon the states until 2010. And that occurred in the case of McDonald versus Chicago in 2010, 561 U.S. 742. So now we have a situation where they said that the Second Amendment could not be infringed by the federal government. Okay? When it was incorporated upon the states, it now is possible to assert that neither can the states infringe your right to keep and bear arms. That's based on a Second Amendment argument, though. You see, you have to understand it's strictly based on a Second Amendment argument. It does not speak to the inherent and inalienable nature of the right of self-protection and the right to life and the right to keep and bear arms. It doesn't speak to that. It just says we're actually discussing. If you were in a discussion, you say, well, when did the Second Amendment infringement clause become applicable to the states? And you mean it wasn't even applicable to the states until 2010, from when the Constitution was and the Bill of Rights were ratified? It wasn't even applicable? Well, that's correct. It wasn't. Before 2010, you were actually dependent upon the states to take care of the protection of your right to life and right to keep and bear arms. And the states were handling it. Now, why is that? To a lot of people that doesn't really make sense. And they would say, well, you mean, on what kind of an argument would it be that it wouldn't be applicable to the states? And the answer to that is sovereignty. You have federal sovereignty was created by the creation of the federal government. You can also say it was delegated to the federal government by the people and the states. Stop it for a minute. Okay, I had to pause for a second, but we'll continue. So what we were talking about is the incorporation of the Second Amendment upon the states. It didn't happen until 2010. So this ought to tell you, and again, I'm not going to name names or point a finger at anybody in particular, but I will say this, that various 2A groups have allowed the American people, or people who were joining or supporting that group, to believe that the Second Amendment applied to the states before 2010, which it didn't. So when you're making Second Amendment arguments before 2010, that would be frivolous, because the Second Amendment didn't even apply to the states yet. You would have had to address those rights at the state level. And a lot of people didn't know all that. And I dare say today, a lot of people, while they have heard some people say that the right to keep and bear arms is an inherent and inalienable right, they still default back to thinking that it's a Second Amendment right. You see, now that's why when I decided to title this thing Second Amendment Limitations, the Second Amendment has limitations on protecting your rights. And you need to know just how to go about protecting these rights the right way. All right. Two things that I want to talk about. First, I'm going to read from the Constitution. Then I'm going to talk about whether or not inherent and inalienable rights should be subject to a majority vote at all. Or should it have been done this way? And did the Founding Fathers have in mind, by using the non-infringement clause of the Second Amendment at the federal level originally, that to put those rights outside of the reach of government infringement, and that it shouldn't even be subject to being voted on and infringed by a vote? Let me read from the Constitution, the Declaration of Independence, rather. We hold these truths to be self-evident, that all men were created equal. Now it says men, of course, that includes women. That they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. There's your right to life mentioned right there, and there's liberty mentioned right there, because the people created government to protect their rights, freedoms, and liberty, not to take them away. Okay. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. See, governments are instituted among men. Governments don't spring into being by themselves. And then, if a government springs into being by itself and then looks around for men to apply their powers upon, that's a different concept altogether. And so where'd that government come from? And now they're telling us what we can do and what we can't do. And they didn't ask us if we agreed to anything. They just started asserting government power on people. Is that the way it works? Governments just sprang up from nowhere and start asserting powers upon the people and telling the people, these rights you shall have, these rights you shall not have. And you'll only have the rights we give you until we decide to take them away. You see? Then we'll take them away. See, what government grants, if it actually is a government grant, they can take away. Keep that in your mind, because that's important. And it says that they derive such powers from the consent of the governed. Okay, that means that they have to have your consent. Remember, we talked about you join a group and you give the group consent. You say, okay, I agree to this. If the group decides that we're not going to wear orange ties anymore, then I can't wear an orange tie. You see, the group decided. And I thought it was my choice whether I wear what color tie I wear. No, now the group decides. And then they have to remind you. Maybe they remind you, maybe they don't. They say, remember when you agreed, you said we could make a decision like that? If the majority says no orange ties, you don't get to wear an orange tie. That's how that works. Okay. Now, what if the government, which came into being instituted by men, and given, deriving its consent from the consent of the governed, what if they deviate from that and start to get power crazy? What then? Okay. And it says that whenever any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation upon such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Now, if I would have been there when they were writing this, I would have said more than safety and happiness. I would have said their rights, freedom, and liberty. But, it is implied within their safety. Why their safety? To protect the safety of your rights, freedom, and liberty, of course, so that you can have a free state of existence, rather than, what is the other option? A government-controlled existence, instead of a free state of existence. When you agree to this thing, you're saying, okay, I'll agree, but it's with this proviso, that I agree to it as long as you protect my rights, freedom, and liberty. And continue to allow me to live in a state of free existence, then I agree. Then I agree. Then I am willing to let some of my rights slide so that I can be protected in that way. That's if the government is working properly under the proper foundations upon which it was founded. When it no longer does that, I just read you what your options are. Now, this is in the Declaration of Independence. For those who don't know it, the Declaration of Independence is codified in the United States Code. All right, now, democracy. I've written quite a bit actually on democracy, but I'm going to try not to read as much and talk more, because it's probably somewhat boring maybe to watch somebody on camera reading from a piece of paper, and I understand that, but I don't have a photo-eidetic memory, so sometimes I have to read from a piece of paper. In 507 BC, now I talked about this on some of my teachings on the tyranny of the majority vote. In 507 BC in Greece, a Greek came up with demokratia, which became the foundations of what we now call democracy. And I won't go into the details of it like I did before. I'll just tell you that it is at that point that the idea of democracy came into view of humanity and then started to be applied. And now we have for lack of a better way to put it, there are countries upon this earth who are involved in or are pushing global democratic expansionism and saying, well, democracy is such a good system, it's worthy to be spread across the face of the entire globe. I'm not going to directly discuss that, but I will tell you this. For those of you who are believers in God, democracy is nowhere supported in the Bible. And that's a problem for believers in God. Now, there are people out there who don't believe in God and say, well, that doesn't apply to me. I don't even believe in God, and I don't believe the Bible is authoritative, and I'm not going to worry about whether it's supported or not supported in the Bible. All right, fine. The thing is here, I'm really trying to talk not to everybody, although I wish everybody would listen, but I'm trying to talk to those who are concerned about protecting the right to keep and bear arms. I guess there are people out there who aren't concerned about that. They say, okay, yeah, take away my right to keep and bear arms. I don't care. And by the way, they are also, there are guys that, I saw one guy, he had a AR-15, and they actually have a video of him sawing his AR-15 in pieces with a chop saw. And I'm making some kind of demonstrative statement about the evils of this firearm. Well, I wouldn't have done that, and I think it really wasn't necessary for anybody to show that. But I understand, you're pushing an agenda, you're pushing a philosophy, you're pushing a belief, and that's what you do. You show somebody sawing their AR-15 in half, or melting down their handgun, or whatever it is they're going to show. The thing is, I don't have a problem with somebody wanting to destroy their own firearm or melting down their own firearm, but when they say to you, and we're going to take and destroy your firearms as well, that's when they've gone too far. They're now stepping outside the consent of the governed. You may have made the mistake, though, of not telling the government that you withdraw your consent. You may have made that mistake. And we're going to talk about this in this video, about, what do we do about that? The trouble is, as I told you, inherent and inalienable rights belong to everybody individually. We're all created upon equal terms. And by the way, when we were talking about governments supposedly springing up out of nowhere, out of thin air, then you're saying they were not instituted among men. They just sprang up. evidently populated by people who are also endowed with equally to us. And now these people in government are telling us what rights we have and don't have. Like I said, if they have your consent, fair enough. They've got your consent. If you say, yep, they say nothing more than a 10-round magazine, yep, I agreed to that. You can't have a semi-automatic firearm. You jump up and say, yep, I agreed to that. They say, we want to saw various weapons that look a certain way, like a AR-15. Those are scary looking, so we're going to saw those up. Yep, I agreed to that too. Or they might say you can't have hollow point rounds. That's only for the military, they might say. Yep, I agree to that. You just yep your way until you have nothing but sticks and stones to fight with. But anyway, the point is, if you agree to it, that's one thing. If you don't agree to it, it's another. Yeah.
Would you say that the act of voting itself is agreeing to the terms of the outcome?
Yeah, I'm going there. Oh. Yeah. Okay. Here is the problem. Here's the problem. When you say that the majority can vote your rights away, and you haven't done anything to have them think otherwise, there is presumed and assumed consent from you, and you fail to object in a timely manner. You have to object in a timely manner. And can you just, you can't just do like Rocky did and open the window and say, hey, yous, I don't agree, that won't work. You see, you're going to have to do it in writing. You're going to have to do it by certified mail. You're going to have to do it in a manner that is legally effective and recordable, saying, I did this. Because they say, you never notified me. Somebody might say, he says he withdrew consent. I don't remember. When was that? What did he do? Yell out the window like Rocky? Or what did he do? You see, or if you send just a piece of paper and you're scribbled, I remove consent, and put it in an envelope and send it to him, or send him an email and say, I remove consent and your name under it, and then you send an email, that's not good enough. That's not going to work. Okay, now, otherwise, yes, I agree. If you consent to it, that the majority vote can take your rights away, well, okay, you consented to it. It's kind of like a consent search. If the cops come around, and of course I've talked to you about DUI checkpoints, and I've talked to you about police-citizen encounters, and if you open the door and the police say, do you mind if we look in your trunk? Do you mind if we search your car? Do you mind if we look around your house? And you say, no, I don't mind. Come in and look around. I got nothing to hide. I don't mind. Look to your heart's content. Well, if you do that, you have given them consent to do that. And when you go to court, the court's going to say, this was a consent search. Say, yeah, but they found something I didn't want them to find. Yeah, but you gave them consent. Well, I object that they found something that I didn't want them to find. Well, that's too late. You gave them a consent search, you see. You have to say, I do not consent to searches. You can say on advice of counsel, or you can say with respect, officer, I do not consent to searches. With respect, officer, on advice of counsel, I do not consent to searches. You can do that. You can remove consent. You have to do the same thing with these other rights. Now, here's the problem. Let's say, like now, in the two-way dilemma that we have before us, where there are those who want to take our rights away, our Second Amendment. Our Second Amendment, I almost said it myself. See, it's easy to get confused in your mind. You have to constantly remind yourself it's not a Second Amendment right. The thing is, you have to be clear about what comes out of your mouth. You have to be clear about what you write down on paper. The truth of the matter is, in the environment that we have today, and people are saying, well, they're trying to pass legislation, anti-gun legislation, and we're going to vote it down. And to say, so we're going to rally a bunch of 2A people together and say, hey, let's all vote it down, or let's start a petition, or let's do whatever. Okay, the problem is, here is the problem, and please don't forget it. If you do that, you are saying that your inalienable right to self-protection and to life and the right to keep and bear arms can be voted upon. When you do that, that's called by operation of law. By operation of law and by your own actions, you're saying, yes, I am by my own actions implying and saying and acting out that these inalienable and inherent rights can be voted upon. Then if it doesn't work, then and the legislation does go through and they start taking people's guns away, let's say, or various types of guns away, or they say, well, we're going to outlaw anything more than a 10-round magazine. And my son pointed out, and he's quite right, he pointed out, he says, you can be charged just for having the magazine, even if there's no gun to put it in your possession. Because they've outlawed that kind of a magazine, a high-capacity magazine over 10 rounds, it's outlawed. They can charge you just for having the magazine.
There's already case precedent to that.
Yeah, there's already case precedent to that. He's just stating it's true. So, what we've got to do, now I know how you feel about it. You're saying, but Pastor Mike, if we don't vote on these things, how will our wants and desires and our protection of our rights be done? How will we be heard? The only way that we can be heard and have any influence on any of this is if we vote. And now you're implying that we shouldn't vote on an issue like that. Yes, that's what I'm implying, and I'm going to get into it more. Yes, that's exactly what I'm implying. The fact that you're voting on it at all says it can be voted upon, and it should not be voted upon. Now, I'm deviating a lot from what the 2A movement is doing. Now, some of you know me that are going to watch this video. Some of you don't. Some of you have read some of what I've written. Some of you have seen some of my videos. And I can guarantee you that Pastor Mike does not do anything, or much of anything, without a plan and a strategy. So, here's what I'm saying by that. I'm not saying that I'm the super smart guy you should all flock to and say, Pastor Mike is super smart, we should all flock to him and do whatever he says. No, I don't even want you to do that. I want you to hear the truth and decide for yourself whether what I say is true or not. And then you make the decision. Don't have me to make the decision for you. I don't do that. Okay, so I am telling you flat out, these rights should not be voted upon. You vote on it, all the evidence that can ever be used against you will mostly be provided by you or not completely provided by you. And that's evidence that you're providing that your inherent and inalienable rights are a proper object to be voted in or out of your life. That's evidence of that. Let me say that again. That's evidence that you're providing that your inherent and inalienable rights can be voted in or out of your life by the majority or by the majority vote of representatives that you voted for. Okay, so you vote for government representatives, and that government representative supports anti-gun legislation. Or they vote on it, he may have voted against it, but there wasn't enough. Wasn't enough on your side. The other side carried the day, and they said, there goes your rights. Because it was subjected to a direct or indirect majority vote. That's what's happening, and that's what you have to guard against. You have to understand the issue before you can really strategize and deal with the issue. And that's what I'm here to talk to you about today. So, I don't want to spend an inordinate amount of time on this tyranny of the majority, but when they don't have your consent, and the majority of the people even, not just the people that are in the government, that by some kind of voting process got into that government, instituted among men, governing by the consent of the governed. See where the assumed and presumed consent comes from? It all back engineers onto you. You allowed me to do this. The power to do it comes from you. That's how it back engineers onto you. I'm just doing what you said what you gave us the power to do. We're trying to carry out your will. Carrying out your will. That's how it's going to play out. All right, now, so what do we do about it? Is there anything we can do about it? Should we just throw up our hands and say, I don't know what to do? I listened to Pastor Mike, and I'm more confused than I was before I listened to him. So let me talk to somebody. Let me talk to a lawyer and see what they say. Let me talk to a 2A person in the hierarchy of the 2A group. Let me talk to them, see what they say. They say, oh, Pastor Mike, you listen to him and you won't be voting on your Second Amendment constitutional rights, and now you're really messed up, you see. Don't listen to Pastor Mike, for God's sake. That guy's all messed up. Well, these are your decisions. You decide. You listen to the players in this thing. I'm hoping that I will rise to the level of a player that you will listen to. And you say, well, we listened to Pastor Mike, and I don't know, I'm kind of confused, I don't feel safe with his approach. I feel safe with the 2A group because Pastor Mike doesn't have any big groups, it doesn't look like, but these 2A groups are pretty big, and they got lawyers, and they got money, and they're collecting signatures, and boy, I feel safe. It's kind of like you're a gazelle in a herd of other gazelle, and you say, well, in this herd, maybe I won't get picked off. Well, okay, all right, if that gives you a feeling of security. I'm not here to give you a feeling of herd security. I'm here to tell you how the law actually breaks down and how these rights actually break down and what the proper workings of them are. And it took me a long time to put all this together. It didn't come easy. All right, I'm going to go to the board. I drew something up, and maybe it'll help you understand where we're going with all this. Let me remove this visual aid right here. We don't need this one at the moment. I just drew this thing up yesterday. All right. If you look at this graph kind of that I made, it starts with God. That's for believers. If you're not a believer, the graph can be a little bit different. Not a whole lot different, but somewhat different. God created humanity with inherent and inalienable rights. Okay? From there, let's move down to the Declaration of Independence, from which we have just read. All right, then from there, beyond that, you get the U.S. Constitution. And from the U.S. Constitution, you get the Bill of Rights. The government, the federal government, came into being through the U.S. Constitution because it was instituted among men by the consent of the governed. You go down here to the Bill of Rights, and you have the Second Amendment and the non-infringement clause under the Second Amendment. Okay? Then you have the people and the voting. That's why I wrote voting here with an arrow pointing at the people. Then below that, you have the individual person who were part of the people. When the people form into a group, well, you're one of the people, so you're an individual. Unfortunately, when I made the graph, you're at the bottom of the graph. That doesn't mean that you're the least important aspect of what we're speaking about here. All right, now, I wrote here government, U.S. Constitution, federal. When the Second Amendment was incorporated upon the states, it also then included the state. What was included on the state? The non-infringement clause was included upon the state. All right, now, you see where I drew a line here with an arrow and a line here with an arrow, and I wrote blocked and blocked. So in other words, there's a barrier here at the U.S. Constitution. What does this barrier do to you? Depending on your understanding of the issues, what it does, it blocks you from being able to, blocks the people and the individual from being able to access their inherent and inalienable rights directly. That's what it does. What then do you have? Well, then you have, because of this blockage, then all you have are constitutional rights. And the Bill of Rights and the Second Amendment infringement clause and all that. That's what you're blocked by. Now, they're even considering that there's a blockage here, and they're saying, well, you can't do that. Yeah, I know you're talking as if the Second Amendment rights are inherent and inalienable, but we're calling those constitutional rights, as if it flows only from the Constitution on down. That is not how it works. The only way that the people and the individual person is going to access their inherent and inalienable rights is to get by this blockage. That's why this arrow goes around the blockage up to inherent and inalienable rights. Now, here is another problem that I want to talk about. Why is it not going to be effective to hire an attorney for you to get your inherent and inalienable rights? Why can't you do that? Shouldn't that be possible? Well, the answer is that the attorneys are blocked by this blockage as well. How are they going to get around the blockage? Do they have a way around the blockage? They may understand that your rights are, in some degree, inherent and inalienable, but they can't go beyond the blockage. Now, what would stop an attorney from getting around this blockage?
You mean they also believe the Constitution is the only vehicle through which it can be exercised?
It doesn't matter what they believe. What matters is what law are they bound to. Okay? They may have all kinds of beliefs. So, oftentimes it does not. When you're dealing with law, what you believe and do not believe is not the determining factor. What matters is what laws or what barriers are you restrained by. That's what matters. Okay, so an attorney is sworn upon oath to uphold the U.S. Constitution. Therefore, if he tries to argue a rights case for you, trying to get you up to your inherent and inalienable rights, he's not really empowered to do that. He's not really empowered to do that. He may be knowledgeable enough to make the arguments, but he's taking a risk. Now, there are clauses in the Bill of Rights, the 9th and 10th Amendments, which could be argued to allow you to get around the blockage. However, be aware that the 9th and 10th Amendments have not been incorporated onto the states at this point. And they're not likely to be. All right, now, even under the blockage, well, let's say that you would argue, even under the blockage, I'm happy with my Second Amendment rights. But the trouble is, they're not even letting you have those at this point. They're even infringing on that. Now, I agree. If we're right here blocked, and you say, I'm happy being blocked. My Second Amendment rights work for me. And they're not taking my rights away, and I can keep my AR-15, and I can, whatever. We won the vote on the high cap magazines, and I get to keep my high cap magazines, and I'm okay with that. All right. Well, if you're happy with that, and you say, I'm not motivated, Pastor Mike, to go around this blockage and get to my inherent and inalienable rights. I'm not motivated. All right. The thing is, you are still existing by the tyranny of the majority at this level. That's what's happening. They can vote those rights in and out of your life. Because, and under the assumed consent and presumed consent that you gave them, that you say, yeah, this is something that can be voted upon. Now, maybe once you look at this graph, and maybe once I explain it in a certain way, you begin to understand how this all really works. Now, I would suggest to you that, let me explain another thing. I would suggest to you that you're much better off with your inherent and inalienable rights getting around the blockage than you would be without it. Also, you know, you have a situation where when they charge you with a felony. Now, you remember I made a video before and said that it was the shell game, more or less, the smoke and mirrors shell game of moving the bar on what constitutes a felony. What they could do now is say, we passed a law that infringes on your Second Amendment rights, and you violated the law, and therefore we're charging you with a felony, and therefore you can never have your right to keep and bear arms again, because we charged you with a felony. At this level, that is entirely possible that would happen. Why is that? Because you didn't get around the blockage. At the inherent and inalienable right level, that's not true. When, let's say you're charged with a crime, you pay your debt to society. Let's say they fine you or have you serve a certain amount of time incarcerated, and you do that, and you say, okay, I served my time, I paid my debt to society, I want my right to keep and bear arms back, because it's part of my right to life and part of my right to self-protection. I want it back. You can't, how are you going to get it back if they do that? Then what do? See, the only safe way is to get back up to your inherent and inalienable rights, because these inherent and inalienable rights should be beyond the tyranny of the majority and infringement by government legislation. That's what it should be beyond. Do you have anything to say about what I've explained here?
Yeah, one thing. The courts, particularly recently, are more and more calling rights privileges instead of, they're calling things privileges instead of rights.
Right.
They're using the word privileges in case decisions.
Okay. Yeah, good point. Let's get away from the board now. Okay, what my son's talking about, he's right, I've read it myself. They are saying in some case opinions, case precedent opinions, instead of using the words rights, they're using privileges. And I don't know if it's just a slip up on their part, or whether it's deliberate, or whether it's agenda based or whatever, but we should not let them play such games with our rights. If they are rights, we need to be calling them rights. The Bill of Rights, if we go by the below the barrier concept, the Bill of Rights is not a Bill of Privileges, it's a Bill of Rights. As a matter of fact, as I've said numerous times before, the Bill of Rights was misnamed. It should have been called the Bill of Protections of Inalienable or Inherent Rights. Or inherent, actually, both. Inherent and inalienable rights. The Bill of Protections of those inherent rights. That's what it should have been called. But see, the thing of it is, if we learn from Cruikshank that the Second Amendment did not create the right to keep and bear arms. It merely prevents the government from infringing rights you already had. Just get it in your mind. You already had these rights. Now, what kind of rights am I talking about? My visual aid's over there, and I'm kind of reading it sideways. It's pre-existing rights. It pre-exists. It's inherent. It's natural. It's human, and it's a God-given inalienable right. Also, Justice Scalia, the late Justice Scalia, called them pre-political rights. They predate the political system. And when he said that in D.C. versus Heller, 554 U.S. 570 in 2008. It was just 2 years before the McDonald decision, in which the Second Amendment was incorporated onto the states. Now, try not to forget It doesn't mean, when it's incorporated upon the states, it doesn't mean that now you're being granted the right because it's incorporated on the states, now by the states. No, at the state level, it's the same thing. They're also not allowed to infringe your inherent rights and inalienable rights. That's what it means. It's just being imposed upon the states. Remember that state governments, neither did they spring into being all by themselves. They too were instituted among men. See? We have to be able to mentally and intellectually work the problem so that we understand the legal principles and the dynamic of it all, how it all fits together. It's important. It's very important. Okay. Anything else you want to bring up other than that? Okay. All right, let's move on. The awful truth about voting, by the way, if you haven't seen that video, you can go to where my videos are and you can look at that. I highly recommend that you do that. All right, now let's go to the other thing that I want to talk about, and that has to do with consent. What do we do then? Let's say we follow the strategy that Pastor Mike seems to be laying out. How do we go about doing that? Because people will rightly wonder. They'll say, but Pastor Mike, won't they then just go ahead and pass this anti-gun legislation at some point? And then, wow, then they got the law to use on us. And we didn't vote. You told us not to vote, so we, silly us, we listened to you and didn't vote. Because we didn't want them to throw that back on our face that we voted, said that the thing could be voted on, so we didn't vote. Now, see, Pastor Mike, what have you done to us, Pastor Mike? They voted the law into existence and now they got one. Well, I can tell you this, the way things are looking at the moment, sooner or later that's going to happen anyway. Sooner or later, some form of really oppressive anti-gun legislation is going to get on the books. It's going to get on the books. All right. What protections do we have then? Let me add also, once they disarm the people, the citizenry, your rights, freedoms, and liberty will follow. Let me say it again for emphasis. Once they disarm the people and you don't have your right to keep bear arms anymore, or diminished to the point of, absurdity. So it's like me throwing rocks at people with guns, and you're going to lose. Unless you're close enough to hit them with a rock and take their gun, you're going to lose. All right. What do we do? What do we do? They got this anti-gun legislation on the books. It's signed into law by people who want to take your guns away. Tyranny of the majority in action. Well, here's what you got to do. This is tough for you guys. This is tough for 2A groups. The 2A people will go, what a silly strategy Pastor Mike has. Well, let's see if it's silly. Let's see just how silly my strategy is. Remember, now you understand. We've got to get up to our inherent and inalienable rights. How are we going to do that? Can we go to a lawyer and do it? And the answer is no, you can't. It won't. He's not going to be able to do it for you without risking disbarment or severe chastisement for not sticking with the sandbox that he was licensed to play in.
The limitations of the Constitution.
Limitations, yeah. Limited by the Second Amendment, and that's why this thing is called Second Amendment limitations. How do we get past these limitations? All right. I explained enough to you now so that you understand that they are assuming and presuming they have consent. Okay. Now, this is one of the few times that I'm going to actually talk about this legal notice that I have here, which is entitled Articles of Clarification of the No Consent Issue, or in the alternative, Withdrawal of Consent. This is my own withdrawal of consent form right here that I sent in. I'm going to explain step by step what's in this legal notice. You see, once I serve the legal notice on them, then I have removed the problem of them assuming and presuming consent at my individual level. I want you to understand, and I'm not going to, I hope, sometimes the way I speak, it sounds like that I don't care about you. No, I do. I just have a manner of speaking which isn't, if you want somebody to do your public relations work, it's not going to be me or my son. Neither one of us are good at it, you see. We get to the point too directly. We make statements very directly. We adhere to principles very directly. And a lot of people find that distasteful. And I agree, maybe it is distasteful. That doesn't mean I'm not right. It just means my methodology and my personality is not tasteful for a lot of people. Okay, because it's going to be hard for you to do this, and I understand it's hard, but I'm going to walk you through it, okay? Yes, we're going to have to hold back our vote until this anti-gun legislation comes in. It's going to come in. I'm not a betting man, but I almost take bets on it. Yeah, it's going to come in at some point. And it's kind of like the rungs of a ladder. Maybe they can't get the whole anti-gun package in all at once. Maybe they'll just get part of it in. And that's the first rung of the ladder. And don't make no mistake about it. They're going to go up the ladder to other rungs of the ladder. Or if it's a stairway, they're going to start walking up the stairway. Yeah.
Another trick that's being used and that people should bear in mind is that they will try to get a law in that everybody agrees is fairly reasonable. Mm-hmm. Once it's in and there's no more public attention, they can bureaucratically and very easily alter or change that law.
Correct.
To mean what they want it to mean. For example, if they say, look, we're only going to ban magazines over 20 rounds. And everybody says, well, they're giving me 20-round magazines. That seems reasonable. Once the law is in, they can drop that down to 5-round magazines.
Correct.
And there's no more necessary going through getting the law passed.
It might even be in the fine print of the law that it can be modified.
Yeah.
It might even be there. Fine print. You're going to be involved in law? Fine print. You're going to have to look at the fine print. They've already done this, by the way, what my son is talking about. They've already done this with the Patriot Act. With the Patriot Act, when it first came in, it was 2,500 pages. And by the way, the people who passed it, a lot of them didn't read the 2,500 pages. They just passed it. It grew after it was passed into law to over 10,000 pages. Now, would you say that there's some addition there? Would you say there's some modification within that kind of a scenario? Well, of course there is. You see, of course there is. All right, so they're going to pass the law, and you're going to say, well, I got to be able to protect myself now. Okay, well, let me first speak for a while about the legal notice. This was sent in by certified mail, return receipt requested. Let me emphasize, it must be sent in by certified mail, return receipt requested, and you're going to have to pay some money for that. It's probably under $10 to do it. Like I said, it will be well spent $10. I'm going to leave out some personal things that are in this particular notice because it's personal stuff of mine that I don't want to read. But anyway, I'll go ahead. Article 1 of my legal notice says, legal notice is hereby given by Michael Benjamins Jr., date of birth, then I gave my date of birth, a private individual and a pastor in the Remnant Church located in the city I'm located in Oregon, occupying a dwelling at, then I gave my address, and then I put email address, then I gave my email address, phone number, then I gave my phone number. Hereinafter referred to as the undersigned. Okay, that's something you do in law so that you don't have to say the same thing over and over again. You just say that person who's filing this notice is hereinafter in the body of the text going to be called the undersigned. Okay, so you don't have to say the same thing over and again. Article 2, whereas the state of Oregon is a governmental entity, which is a state of the United States of America, which is therefore bound by the U.S. Constitution, whose authorized government personnel holding public office are sworn upon oath to uphold said U.S. Constitution, legal notice is hereby given, delivered, or otherwise received by the state of Oregon, hereinafter referred to as the state. So they're calling me, I'm going to call myself the undersigned, and we'll call all of that stuff that I said in the narrative, we're going to call the state. Okay, simplifies things. Article 3, whereas the Oregon Department of Justice, located at 1162 Court Street, Northeast, Salem, Oregon, 97301, and then I gave their phone number, is a duly authorized department, office, and functionary of the state of Oregon, hereinafter called the ODOJ, so the Oregon Department of Justice, I just took the letters out, made an acronym, ODOJ, upon which legal notice on behalf of the state, of said state, may be given, delivered to, or otherwise received by. Legal notice shall be deemed sufficient and complete. All I'm saying there in Article 3 is that the Oregon Department of Justice is authorized to receive legal notice on behalf of the state. That's all I'm saying there. Okay? Further notifications may be pending by way of certified copies of this notice upon the state of Oregon through the Oregon Department of Justice, by delivery to various other branches of government operating in departments, offices, representatives, functionaries, or personnel, etc., at varying levels of government. That's just fancy talk for, I'm going to serve copies of this on other people within the governmental structure of the state when and if needed. That's all I'm saying there. Okay? Just fancy legal language for saying that you may be serving it on other people. Article 4, whereas the people of the United States, as well as the people within any state of the United States, hereinafter referred to as the people. See, after that I'm going to call the people, okay, hold sovereign status as evidence and acknowledged by and in the Supreme Court case of Chisholm versus Georgia, and then I give the case cite, in which Supreme Court Justice John Jay wrote, and then I state what he already read you that part. And the sovereign status of the people is further reflected in the history of the United States. It is, therefore, the people who created the government, as well as the U.S. Constitution upon which the government is established. Moreover, it is the sovereign people who created the government of the individual states of the United States, as well as the constitutions upon which state governments are established. The historical record of the United States also reflects that, and then I made a little quote from the Declaration of Independence. I'll read it again just for emphasis. We hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, the Declaration of Independence of 1776, and I also wrote, which is codified as part of the United States Code. Okay. Article 5. Whereas the people are endowed with various rights, including but not limited to pre-existing, inherent, natural, human, and God-given inalienable rights, also referred to as pre-political rights by the late Supreme Court Justice Antonin G. Scalia in D.C. versus Heller, and then I give the case cite and the year. all such rights hereinafter to simply be referred to as inherent rights. So in this document, when I say inherent rights, I mean all that stuff, okay? Which rights pre-exist the states, state government and laws, the U.S. Constitution and its amendments, the federal government and its laws, and do not come from and were not granted by such state and federal governments, but which governments are created by the people to secure and protect such pre-existing inherent rights, wherein the Bill of Rights should more properly have been named the Bill of Protections of Inherent Rights. That among such inherent rights, I go into a little bit here about what kind of inherent and inalienable rights. What are we talking about? And you always want to say that when you're doing something like I'm doing here, you say that among such inherent rights of the people, but not limited only to those set forth herein, you want to say, yes, I'm going to name some rights, but it's not limited only to the ones I name. You're leaving it open-ended. You're saying, I want the right to be able to claim other rights that I didn't talk about right at this moment. That's why you do that. Otherwise, in law, it's very specific. They'll hold you to your pleadings. They'll hold you to your writings. And they'll say, well, you only said you wanted the right to keep and bear arms. You didn't say that it wasn't limited to that. And therefore, your right to bear arms you can have, but we'll take away every other inherent and inalienable right we can get our hands on. You see, you have to be careful for that when you're dealing with legal writing. But not limited to let's see, wait a minute, I'm reading the wrong place. That these rights are, and then I list some of the rights. The right of and to life, liberty, and property, and the existence in a state of freedom, which the Second Amendment is called a free state of existence. The right to have a real relationship and access to the sovereignty and jurisdiction of the biblical God. The right to access the legal authority of the word of the biblical God in both belief, rights of conscience. Just belief is called rights of conscience in legal terminology, and scripturally mandated conduct, free exercise of biblical doctrine within a genuine, not one-sided, no-harm rule model. Okay, I'm not going to talk about the no-harm rule right now. I did that before in other videos. As set forth in the Holy Biblical Writ, with the right of self-protection by the keeping and bearing of arms. I'm just continuing now with more rights, inalienable inherent rights, with the keeping and bearing of adequate arms, the right of and to freedom of speech, the right of association with others, the right to contract, the right to move from place to place, the right to have a family and children, including holy matrimony under the sovereignty and jurisdiction of the biblical God, or a civil state marriage. You see, I'm saying you can have one or the other. You can have holy matrimony under the sovereignty and jurisdiction of the biblical God, or a civil state marriage. One or the other you can have. The right to shelter from the elements, a home, in a legally private, not commercially regulated model of freedom, as well as other inherent rights not specifically mentioned herein. See, I put a clause in there saying, as well as other inherent rights that I didn't specifically talk about. Okay. Article 6, whereas. When you say whereas, then that's like saying because of that. So you just use the word whereas, it does the same thing. The sovereignty of the people is not held only as a collective or joint sovereignty, but it relates specifically to inherent rights. As it relates to inherent rights, is an individual sovereignty, that those who choose to exercise such individual sovereignty and inherent rights, independent of the collective sovereignty of the whole or the majority of the people, may opt to do so. I'm saying here that you can opt to do it individually. You don't have to do it only as part of the collective people. It's just like saying if you're going to argue a militia argument, because there's a militia clause in the Second Amendment. it doesn't. The Second Amendment doesn't mean that you can only have the right to keep and bear arms as a militia. You can have the right to keep and bear arms outside of a militia. The Militia Act was created, approximately 200 years ago. So it doesn't make any sense. Anybody who's going to argue this militia thing over and over and over, I'm telling you, that's not the only way that you can have the right as part of a militia. Just be aware of that. Article 7. I'm building up to the crescendo of this notice, by the way. Building up to it step by step. Article 7. Whereas genuine inherent rights, which are held by the sovereign people collectively, I put and or individually. I've stopped using and or, but I'm not going to talk about that. Are not subject to incremental or complete predation or encroachment by the majority vote of either a majority vote of the collective people, their government representatives, or by executive, legislative, or judicial acts or omissions without their consent. I'm saying here, you can't use predatory legislative actions to take away people's rights, freedom, and liberty without their consent. That's what I'm saying. I'm emphasizing it here. While there may be those among the people who choose to subject their inherent rights to a majority vote, we spoke about that. Some people might opt to do that. Individuals among the people who do not so choose and do not consent to such diminishment or encroachments in whole or part, so you throw in whole or part, either the whole thereof or in part, upon their inherent rights, may assert an individual access and exercise of their inherent rights. It's pretty simple language, really, the meaning of it. You're simply saying that the individual may assert their inherent and inalienable rights separate from the collective. It is evident in the wording of various laws, such as the Second Amendment clause, shall not be infringed, which is very clear and understandable legal language, that inherent rights, such as the right of self-protection by the keeping and bearing of adequate arms, is a pre-existing, inherent, and inalienable right which is, by its very nature, interwoven into the protection of life, liberty, property, and free existence, for example, and is therefore, absent clear consent to do so, doctrinally beyond infringement by a majority vote. So too, we see other legal language within the U.S. Constitution, such as Congress shall make no law. First Amendment to the U.S. Constitution, that's where it uses that wording. It says Congress shall make no law. They have tried to get around that by saying, well, yeah, it stops Congress from making such a law, but what if the president does it by executive order? What if a governor does it by executive order? Don't even go to the legislature. Don't even wait for the legislature. This is, well, I'm just going to outlaw something by executive order. I'm not going to go into that now, but I mentioned it here. Just remember that I mentioned it here. Congress shall make no law. Judge Napolitano pointed out, he says, what part of Congress shall make no law don't they understand? Is it too complicated language for them? Congress shall make no law sounds... I know children that if you ask themselves, if you read that to them, it says, what do you think that means? It says, well, they're not supposed to make a law about it. Even a child can figure it out. Probably not too young, but I mean, an older child does a little bit of education. They'll say, yeah, Congress shall make no law. Okay. In terms of the Second Amendment, which is now applicable to the states by way of incremental incorporation of the Bill of Rights upon the states, pursuant to the U.S. Supreme Court case of McDonald versus Chicago, and then I give the cite and all, opens the door, at least from a federal constitution application point of view, for applicable constitutional deterrent against infringement of the right of self-protection. Here again, even if through some form or species of majority vote it comes out in favor of self-protection self-protection and arms rights, it still carries with it the specter of subjecting inherent rights, which are beyond standing or falling by such a practice and procedure, to a majority vote, when in fact it isn't a proper question, matter in dispute, or issue to be voted upon. I'll read that again. It isn't a proper question, matter in dispute, or issue to be voted upon. Now, it could be if everybody consented to it. It could be if everybody said, yeah, we agree. If they say, okay, nobody can recolor their hair anymore with the products you buy at the store and color your hair a different color. If they say, well, we're subjecting that to a vote and we don't like people to recolor their hair a different color, so you can't do that anymore, we passed a law. And you can say, well, yeah, we all consented to that. Sorry, brunettes, you don't get to be blondes no more. Sorry, blondes, you don't get to be brunettes, because it's against the law now. Okay? It's a ridiculous example, but you get the idea. We err. In other words, when I say err, we were making a mistake. We're misunderstanding what should have been the right thing. If we focus unnecessarily upon the intent of the framers of the U.S. Constitution, for example, when it is not determinative in the pristine clarity of the true pre-existing nature of inherent rights. You see, it does not matter what the framers were thinking when they wrote the Second Amendment. It does not matter. And they play that game in appellate jurisprudence all the time. You see, they'll say, okay, well, there's a question about the Second Amendment, and we're going to go back in history and get some historian or some legal professional who's gone back in history and say, okay, we did some studies, and here's what they meant when they wrote the Second Amendment, and that's going to be controlling. No, it isn't. No, it isn't. They say, well, yeah, that decides it. Some guy 200 years ago, this is what he meant, and there goes our rights. He didn't mean that they were inalienable and inherent rights. He didn't mean that the government wasn't the one who granted them to you. He didn't mean that, because we found some kind of a note he made or something like that, or a book he wrote, and he wrote something down, and here's what he was thinking. And that determines your right forever. You see?
You mean you're saying then, if I understand correctly, the Founding Fathers' attitudes were determinative of the Constitution, but not of inalienable rights?
No, I'm not exactly saying that. They might have actually had inherent inalienable rights in mind, right, but they didn't address it. In the Second Amendment, they were saying that the federal government was not to infringe these inherent inalienable rights you already had. That's what the Second Amendment is about. I don't want to venture too far from the Second Amendment, but that's what they're saying, you see. That's basically what they're saying. And the Cruikshank Court in 1875 acknowledged that.
But it does sound like you are saying that your inalienable or inherent rights do not depend on the thinking of the Founding Fathers or the Constitution.
That's correct. That's correct. That is exactly right. See, when we start talking about, we may be able to go back with some historical research and say, okay, well, when the founders were thinking about what to put into the Second Amendment and other amendments and all that, and it took a while, by the way. They didn't do this overnight. The Bill of Rights was put together over term of a time period. So they put some thought into it. And then they're saying, well, by saying that it depends on what the framers were thinking, you're saying that the amendments as written themselves have the power to do away with your inalienable and inherent rights. You see? And that's why it becomes important to say, what were they thinking? Because the amendment itself has that power, which it does not. So I don't know if that clarifies for you. Yeah, okay, all right. All right, now here comes the most important part. of this. This is under Article 8 of this withdrawal of consent notice that I wrote and sent in. Wherefore is another way of saying because of that, you see. Wherefore, upon saying because of all the stuff I already said, the undersigned, that's me, by way of a timely legal notice upon the state through the ODOJ, that's the Oregon Department of Justice, hereby clarifies and declares that it was never his intent or act to give consent for the infringement of his inherent rights. And by the way, I just wrote inherent rights here, but remember that includes all that stuff, okay? Through some form or species of majority vote. I am saying here that it was never my intention to give consent for that, all right? Maybe at some point in my life when I was younger and before I became more educated, I didn't understand that. And I was willing to support things because I didn't fully understand them. However, should it at some point be assumed or determined by way of evidence or some application of alleged consent or presumed consent. Alleged consent meaning is saying, we think you gave us consent. We presume that you gave us consent. So that's why I said alleged consent or presumed consent, or by some form of estoppel. I'm not going to talk about estoppel now, but it's a legal doctrine. I've spoken of it in other teachings. That consent from me did in fact exist. So that if they say, however, if you at some point determined that that consent did in fact exist, fortified by my silence, so I said fortified by silence means I failed to object. I just let you presume it existed. Denoted presumed acceptance or consent. So you're saying that your silence means that you give acceptance and consent of the way this works, as well as a failure to object, which means that they're saying, yeah, but you didn't object. As I now do object, I'm saying even if you figured that I didn't object, but as I now do object, right now in this notice, then in the alternative, the undersigned does at this point in time legally notify the state by this legal notice and instrument that he withdraws any and all consent to have his inherent rights subjected to a majority vote, or consent to infringement by other government acts or omissions, such as executive action independent of a voting process. See, if they opt towards not looking at the legislature or Congress and do it by a executive action, I don't give consent for that either. I put that in here, okay? That's Article 8 is the most important part of this withdrawal of consent. Article 9. Now, I know you're getting wore out. This Article 9 is the last article. Okay, let me take a drink. Purpose and scope. Article 9. The purpose of the undersigned is only to complete legal notice as set forth herein upon the state by giving, delivering, sending, or otherwise causing the state through the ODOJ, because they're the ones authorized to receive it upon the state, to receive such legal notice. See, I'm locking in the legal notice. I'm saying, I gave you legal notice. You can't play games. I gave you legal notice. Please be informed that at present, no active or pending legal case exists, and the undersigned is not requesting or requiring any type of response to this instrument. See, I'm telling them there's no case before the court right now involving me on the issue of the right to keep and bear arms or my inalienable rights. There's no such case in existence. So this is not a notice as a corollary to a case that's already been filed. It's not that, okay? The sole object at this juncture is to complete legal notice upon the state. So we have to know what we're doing. What are we doing? We're we're putting legal notice on the state of our withdrawal of consent. That's the sole object of at this point in time. No approval or disapproval, legal evaluation, or specific disposition of this action is necessary. We're saying we're not asking you to do anything about it right now. I just serve this paper on you, and that's the whole of it. All right? If, for example, the state sends this instrument back to the undersigned, let's say they say, oh, the heck with him, we're just going to send it back to him. Okay. Discards it in a refuse bin. Let's say just throw it in a trash can. Okay. Or responds in strong opposition, some of which has occurred in the past when dealing with the government, it will, in the scheme of things, make no significant difference to the factual completion of the timely legal notice. I put that in there because I've been dealing with these kind of legal issues for some time. And sometimes they throw them in the trash can. Sometimes they send it back to you. They say, we're going to send it back to you because we don't know what it means. We don't know what all this is. It's gobbledygook. This is legal gobbledygook. We don't know what it means. Okay, well, they send it back to you. Or they send back a legal evaluation. They said, your legal paper has no merit. It makes no legal, it doesn't lock in any kind of a legal step. It has no authority. It's not really much more important than a picture of Bugs Bunny. You see? So we're gonna tell you that's what the effect of your legal notice is. Okay, what I'm telling them here is, I don't care what you do with it after I served you legal notice. I don't care. You can burn it. You can use it for, shred it up. You can send it back to me. You can, do whatever with it. It doesn't matter. Legal notice is locked in. Okay. Getting right to the end now. The undersigned may, at some future point, should a law or laws infringing his inherent rights be passed by the state or other governmental entity, use this legal notice as evidence in a court of law. See, I'm going to use this legal notice as evidence in a court of law if and when a legal case or issue comes up. I'm going to use it. Meanwhile, the undersigned will be monitoring the acts and or omissions of the state and federal government in the area of infringement of inherent rights. I'm just telling them, I'm watching what you guys are up to. And if you don't do anything crazy, I'm not going to do anything. I just served you notice. I'm telling you what I might be, you're telling them several things. You're telling them you have a plan. You have a plan. You're telling them that you're thinking ahead. You send in this legal notice in anticipation of them passing a law infringing your inherent rights. That's what you're doing. The scope of this legal notice is not limited only to the state, but extends to any other governmental entity acting in concert with the state. Other government entities that may be acting together with the state at all levels to infringe upon the inherent rights of the undersigned. Then there's the signature block. I closed up the signature block like this. Wherefore, the undersigned, Michael Mike Benjamins Jr., a pastor, in his pastoral and individual capacity, does hereby execute this legal notice and instrument on this 11th day of March 2019. Signed by me. Right there. Served upon the state. This was sent by certified mail. Now, I don't want to make this too complicated because maybe I'm already making it more complicated than what you're comfortable with. But you see what it takes to, I should stay centered in front of the camera. Do you see what it takes to send in legal notice? It's not just something that you can do in an email or that you can do in a sticky note and something like that and say, well, I remove consent. That's not good enough. You have got to do something like what I did here. then you have legal notice locked in. Now, I think you're already going, okay, I'm beginning to see what Pastor Mike is up to here. He's waiting. He sends this legal notice in. It already releases to them some ideas or concept about what legal approach he's going to use when and if they pass a law infringing on our inherent rights. He's already got a plan. You see, now, there is part of this thing that may not be apparent to you, but I'll point it out to you. Let's say that they pass a law infringing on our Second Amendment, on our right to keep and bear arms, our inherent and inalienable right to keep and bear arms. Let's say that they pass such a law here in Oregon, but they never bother me personally. You see, they say, well, now this is hypothetical. Let's say that the state says, look, we don't know exactly what this Pastor Mike's going to do, but maybe we should just leave him alone. We'll just take everybody else's guns away and deprive them of their high-capacity magazines and all that. We'll just go after the other people and disarm everybody else who doesn't have a plan, a real good plan, If they do that, my legal notice is of no use to anybody else but me. See, that means I probably won't do anything. They're not coming after me. I can't use this legal notice that I send in for myself to protect you. You're going to have to send in your own legal notice if you want to be protected. So I just thought I'd throw that in so you know. Yeah.
It's probably self-evident, but maybe you should explain the problematic idea of trying to send in a legal notice and voting.
Yes. Okay, if you send in a legal notice like this, and then you go ahead and vote on the legislation, now you're against yourself. You're destroying your own legal strategy. So you don't want to do that. You're going to have to, it's kind of like you're way overweight, and you say that I'm going to pay people money to train me to lose weight and put me on a diet and then proceed to just eat anything and everything that moves, Well, of course, you're against yourself. You see, you can't do it that way.
Undermining your own position.
Yeah, you're undermining your own position. And then you'll have an estoppel problem, by the way. You see, and I'm not going to talk about estoppel. You'll have an estoppel doctrine problem as well if you're not careful about what you're up to. So correct, when you realize that voting on an inherent and inalienable right that should not be voted upon, you can't go ahead and vote and then send this notice in too, You can't do that. It's contradictory and it won't work for you. Anything else?
Yes.
Okay.
What I've noticed when I talk to most of the 2A people is they're attempting to vote this stuff down, but their position is, if the vote fails, their attitude is, we will not comply. Maybe you could speak briefly to the problematic...
Yes, the we will not comply strategy. You see, I actually have a legal strategy. We will not comply strategy is something else. So let's say you're part of a 2A group, or you invested your confidence in the 2A approach. Okay, they're trying to vote this stuff down. Now you already know, because I showed you the graph. I showed you that you got to get up here to where inherent and inalienable rights actually are. Okay, well, when you try to vote, you're already in trouble. When you're voting on these things, you're already in trouble. You're going to have yourself a problem, because you're saying by your own actions, and by those actions, you're saying, I accept the notion that these things can be voted upon. I accept that.
Win or lose.
Yeah, win or lose. Depending on what the outcome of the vote is. If the outcome of the vote is that it's in your favor, then you're happy. But it could go the other way, because it can be voted upon. It can go either way, okay? That's important. So if you have this other strategy, because people will get frustrated, they'll say, look, I put all my eggs in the basket of 2A, and it didn't work out, and they passed the law, and now they're taking all our rights away. Well, that's a dangerous moment, because some people are saying, they're actually voicing this on media, saying, we won't comply. I'm going to dig my heels in, and we won't comply. Well, that's not a really good legal strategy in and of itself. You see, that's not a really good legal strategy, because, the government has had a lot of experience, and I know this because I used to be in law enforcement, has had a lot of experience overcoming people who say we won't comply. And you know what they're going to do? Generally speaking, people with badges and guns are going to do mean, terrible, and awful things to you, you see, and put you in a cage. And then on top of that, you will create other legal consequences, such as you can never have a weapon again, a firearm again, because they'll be charging you with a felony, or they'll be charged whatever they're going to do. Now you've got the added problem of they've taken your rights away forever. The we won't comply thing. Now, if you've really exhausted all your legal remedies, and you've talked nice, and you put perfume on yourself before you talk to them, and you got a haircut, and you talk pretty, and you tried to sugar talk them out of taking your rights away. I got news for you. Sugar talking people who are trying to take your rights away is not a good strategy. It might work on in male-female relations to sugar talk, but it's not going to work too good for this. So don't think you're going to sugar talk these people out of taking your rights away. It isn't going to work. So then you're left with, we won't comply. What worries me is this. When the we won't comply starts not to work, because the government is good at dealing with people who say we won't comply, then we might have people say, they'll reach the last straw, or they'll reach the end of their patience, or they'll say there's nothing left to do but to just do like what the Declaration of Independence says, and that is to overthrow the government and take our rights back. And that's a dangerous moment. I'm trying everything in my power to keep that from happening. I am looking for peaceful legal solutions to our problems, to where people getting frustrated and saying, let's take up arms, and because look what they're doing to us. Even some of their friends might have got shot while they're taking their guns away, you see. Now you got some funerals to attend, and people will, at some point, will reach the point of where they'll be ready to do drastic things. We've seen it before in history, and we've seen it in recent times. Some people out here on the West Coast, took over a federal building by force and things like that, which isn't the solution. But anyway, they did it. It's not that I'm saying they didn't have courage. Some of these people display extraordinary courage, but it wasn't a proper solution for us. It wasn't a proper solution. We have got to exhaust all peaceful remedies. We have got to have a strategy that actually has the possibility of being able to work. Okay, there's a part of this whole video that it leads up to, what do we do once we filed the notice? And they passed the law, and now they're after us. What do we do then? And they charge us. What do we do then? What that gets into the litigation of the actual issue in court, where you're going to use this thing. You see, and that's got to be, that's a complicated matter, actually. That's got to be the subject matter for another instruction. We're not going to address it here now, but that's what it leads to. What then do we do? I'm not going there now in this video. I'm taking you up to this point. I think I've given you enough to think about and try to process. Is there anything you want to do before I close out this video?
Yes, if people wish to see this or other videos, they can go to the YouTube channel Investment in Truth Review, or the other one we just started.
Yeah, real life-changing truth.
Yeah. Or if they wish to see articles and posts, go to which Facebook site?
They can go to a number of my Facebook sites. One of them is Pastor Mike's Advanced Studies in Truth Group, Pastor Mike's Investment in Truth Group, Investment in Truth Review Facebook page. Any one of those, you can start looking things up. But see, I have to keep reposting some of my posts because they get too far down on the line, and then you have to scroll down too far. But I'm pretty good about running some videos and some treatises and posts for a while, and reposting them later. So because not only that, there's new people that come online in the media instruction procedure. So there's new people who haven't seen the stuff yet, even though you may have seen it. But repetition is good. Repetition is good. If you read a treatise that I posted 2 months ago, and then we moved on, and of course there's more writings and more videos, and then we repost them, you see it again, and the repetition of rereading it or re-seeing it is good. It will start to solidify in your mind, and you'll start to have a bigger picture of how all of this works. As always, I want you to know the decision of what to do always remains yours. You see? I don't want anybody to do something because I said to do it. Remember my disclaimer at the beginning. Remember what I said there. You have to look at the issues, maybe do some research yourself, maybe do some reading yourself, and you have to be convinced that I said something that was right or not right or whatever. And when you act or don't act, it should be based upon your conclusions about what's real and not real, what's right and not right, what the law actually means or doesn't mean. So it's always your decision. I'm not telling you how to proceed. I'm telling you that, I'm sharing knowledge with you. You might even call this an educational research study project. And I think that's really, in effect, what it is. I'm sharing this knowledge with you so that you will start to understand. Because in the Bible it says, my people are destroyed for lack of knowledge. Part of my job in this truth ministry that I run is to give you back knowledge so that you are not destroyed for lack of it. That's part of my work. That's part of what I do. If there's nothing else, okay. This is Pastor Mike in Southern Oregon stating, God bless for believers and best wishes for those who aren't believers. Thank you.